Married couples use qualified terminable interest property trusts, or QTIP trusts, to avoid estate taxes and provide for the survivor after one spouse passes, while also protecting assets for other beneficiaries after the second spouse passes. With a QTIP trust, the married grantor, who is the first spouse to die, provides for the surviving spouse. The surviving spouse receives income from the QTIP trust for the rest of the spouse's life, without having to pay taxes when the first spouse passes. The QTIP trust also empowers the grantor to control where the property in the trust goes when the surviving spouse dies. Thus, the grantor spouse can prevent the survivors from disinheriting the grantor's final beneficiaries. QTIP trusts work well in blended families where the spouses have different beneficiaries, usually children that they did not have together. QTIPs also work well for a grantor who is concerned about the surviving spouse remarrying. QTIPs can powerfully protect assets from the creditors and possible predators of the surviving spouse, who might try to take those assets. How does a QTIP trust avoid taxes at the death of the first spouse? All transfers into the QTIP trust qualify for the unlimited marital deduction. Because it qualifies for this deduction, the QTIP trust is a type of marital trust. The unlimited marital deduction allows spouses who are U.S. citizens to transfer any amount of assets to each other, either as lifetime gifts or at death, without estate or gift tax. In other words, this deduction from estate and gift tax in transfers between spouses is unlimited. It can be for any amount. Assets in the QTIP will be included in the surviving spouse's estate and may be subject to estate tax at the surviving spouse's death. To qualify for this special treatment, the IRS provides several requirements for a QTIP trust. First, the surviving spouse must be entitled to all income from the trust for life, to be distributed at least once a year. Second, no person other than the surviving spouse may have an interest in the principal of the trust during the spouse's lifetime. The QTIP may provide the trustee with discretion to distribute principal to the surviving spouse. Third, no person may have a power to appoint any property of the trust to any person other than the surviving spouse during the surviving spouse's lifetime. Fourth, the trustee must make an election on the estate tax return to qualify certain property as QTIP property. How does a QTIP trust work? During the surviving spouse's life, income distributed to the surviving spouse is taxed on the surviving spouse's tax return. When the surviving spouse passes, property in the QTIP trust is included in the surviving spouse's estate, with important estate tax and capital gains tax consequences. Inclusion in the surviving spouse's estate causes a basis adjustment at the surviving spouse's death. The new basis is generally the fair market value of the property on or near the date of death. When the property has increased in value, this new basis is a step up in basis that can result in significant capital gains tax savings. Although estate tax may be due on the QTIP assets when the second spouse passes, it will be paid from the QTIP trust itself. That way, the surviving spouse's heirs will not have to pay the estate tax from the surviving spouse's property. Here's an example of a QTIP trust in flowchart form. Spouse 1 has $15 million in separate property assets. While they are both alive, the spouses form a revocable living trust with QTIP provisions. In community property states like California and Texas, the revocable living trust might be a joint trust. In other states, including Missouri, it's more likely to be a separate property trust. Either way, this diagram tracks only the separate property or property belonging to spouse 1. When spouse 1 dies in 2026, $8 million of spouse 1's assets funds the B trust or credit shelter trust, on the supposition that the estate tax exemption will be about $8 million at that time. The trustee elects to transfer to the QTIP trust certain assets valued at $7 million, but expected to appreciate or grow in value. Spouse 2 does not have to pay any estate or gift taxes at the death of spouse 1. When spouse 2 dies, the final beneficiaries named by spouse 1 receive the property in the QTIP trust. Although it is included in spouse 2's taxable estate, the QTIP may owe estate taxes when spouse 2 dies, depending in part on spouse 2's remaining exemption amount. However, the QTIP assets will also receive a basis adjustment, which will probably be a step-up in basis that may reduce or eliminate capital gains tax. Qualified domestic trusts, or QDOTs, are similar to QTIPs, but are designed to benefit the non-citizen surviving spouse of a U.S. citizen. The QDOT addresses the fact that the IRS does not extend the unlimited marital deduction to surviving spouses who are not U.S. citizens. The QDOT postpones estate taxes when assets pass from the estate of the first spouse to die to the QDOT for the non-citizen spouse. So the surviving spouse does not have to get hit with a tax bill at the death of the first spouse. Transfer taxes are imposed either on principal distributions from the QDOT or at the death of the non-citizen spouse when the assets go to the grantor's final named beneficiaries. A QDOT must meet several requirements to qualify for estate tax deferral. At least one trustee must be a U.S. citizen. The U.S. trustee must have power to withhold estate tax on distributions of principal. The QDOT must be established before the estate tax return is due. As with a QTIP, income distributions are required and are taxable to the recipient spouse as income. Daniel Van Slyke, attorney at law. If you found this video helpful, please hit the like button to help others find it too. If you would like to learn more about estate planning, here's a link to the playlist. For a no-charge review of your estate plan, email me at info@iplanlaw.com or schedule a meeting through my website, www.iplanlaw.com.